good day, and welcome to the Constitution Line by Line. I'm Paul Fabrizio.
And I'm Don Frazier.
And we're delighted you're joining us as we continue our journey.
That I'm joining us? Or they're joining us?
They're the audience,
got it.
viewing, listening audience. They're joining us.
Yes.
On our journey through the Constitution line by line.
Yes, they are. If they've hung with us this long, they're nearly halfway through the Constitution.
They deserve a medal.
They do.
Yeah.
Or a badge.
Or a badge or a certificate. All right. We are now on a brand new article, Article 3. The judicial branch. Are you ready, Don?
I am so ready.
Okay. Here we go. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office.
Okay, so we can have judges. They're going to get paid. They don't get a raise. They don't get it. Well, it doesn't say they don't get a raise. It just says they can't have their pay cut.
Right.
Okay, I was about to say, because if they didn't get a raise and it's a lifetime appointment, that's not so good. And there's a Supreme Court and there's inferior courts.
Right.
Did I get all that?
You got it right. Shall we delve into a little bit?
Absolutely.
Okay. Basically, what we have created from this and subsequent judicial acts is a three-tiered system here in the United States, where there's district courts. There's 94 of them scattered around the United States.
Okay.
And those are called original courts. That's where things start.
Why 94? Why not 95? Why not 92?
Of course, the answer is politics.
Okay.
Every state gets at least one district court.
Okay.
Texas, for example, has 4.
Okay.
And one of those branch offices is located here in beautiful Abilene.
Really?
At the post office, you go to the second floor, and there's a district court.
No feeling. Which one? What's the number?
What's the number? Like, is it 93 or something like that? It doesn't work that way.
Doesn't work that way.
It's simply called the District Court of Northern Texas, I believe.
Oh, wow.
I have some brochures on it, actually, in my office.
Yeah, I imagine you talk about it in class.
And we take tours of it. It actually has its own holding cell that you can go into.
Really?
Yes, and there's this gorgeous courtroom that's there, and you walk in, and it feels like a federal court. And
what does that mean?
You use the word dignify
a
lot. This is a court that is a personification of dignity.
Okay.
And so you walk in, and immediately the college students fall quiet.
Because they're wondering how many outstanding warrants they have.
I don't know about
Probably
that.
not on federal charges,
yeah,
though.
Probably not on federal charges. And at these courts, this is where suits take place. If you're going to file a civil suit that involves federal issues, voting rights cases, for example, this is where people who are charged with criminal activity involving federal statutes. So if somebody robs a bank.
Or counterfeits money,
kidnaps the president's child, something like that.
Yeah.
It all begins at district court, so it's called an original court.
Original court, and there's 94 of them.
94 of them. And then the next level up is the appeals court, and there's 13 of them scattered around the United States.
So 94 squeeze into 13.
Right.
Okay.
And there is one special Court of Appeals in Washington, D.C., which handles governmental matters involving the U.S. government.
Probably high volume.
You better believe it. And these district courts, you have a minimum of 3 judges hearing your case. These appeals courts, you have 3 judges hearing your case because these are appellate courts. Only losers at the original courts, the district courts, can appeal to the appellate courts.
Yeah, it makes no sense if you're a winner to appeal.
Hey,
I don't like this decision. We won.
I didn't get enough money. No, you won.
Yeah.
So, therefore, only losers can appeal, and 3 judges will hear your case. So at the district court, you have a judge and a jury. At the next level, you have 3 judges. Okay.
All right. Spanish would have called that oidores.
Oidores.
And then you'd have heard they're the listeners, the hearers.
Okay.
In Spanish colonial experience, but the idea of a court composed of solely judges,
Judges.
is not without precedent in world history.
Yeah. And at this court, there is no testimony that's given. It's basically lawyers going before these judges and arguing their cases.
And here's how it turned out, but here's how come we think they got it wrong.
Exactly.
What do you three think?
Yeah.
Okay.
And, of course, the other side would say, well, they got it right down at that lower level, and
Yeah.
so you need to leave it alone, judges.
Yeah.
And then at the top level is the U.S. Supreme Court. And, this is how it was established by the Constitution. Now, you notice the Constitution did not say how many judges, or we call them justices, on the Supreme Court there are.
Yeah, that's
It
completely.
just said there is.
Yeah. There is one. Now, y'all sort it out.
Yeah, exactly. And so we've had various numbers from 6 to 10 justices, and we finally settled on 9 justices around the Civil War time.
But there's been attempts to pack the court historically.
There has. Most famously during Franklin Roosevelt's administration.
And the reason being was that the Supreme Court was striking down large chunks of the New Deal as being unconstitutional.
Right.
And so he said, well, I'll fix that. We'll get the Congress, which seems to be dancing to the tune I'm piping, to pass a new Judiciary Act, which expands the court from whatever it was, probably 7 at the time.
No, it was 9.
9 to 15, because guess who would get to make the appointments? That would be FDR. And guess who would be confirming those appointments? The Senate, who likes him.
Mm-hmm.
It was a nice ploy, but Congress saw through it.
Yes.
Okay.
And so it didn't happen.
But there's talk of that happening now.
Exactly. The whole thing is coming up again. All of a sudden, we're talking about court packing again.
And this time by Congress, because they don't like the appointments that the president has put on there.
More specifically, by Democrats running for president and Democrats in the U.S. House of Representatives who weren't involved in it.
Yeah, they don't even have a dog in the fight, but
so.
It's easy. It's a cast-off thing to say, look, we're part of the resistance.
Yes.
Okay.
So
Nice.
Anyway, court packing is always a possibility. It actually is constitutional, if that's what Congress wants to do, because the Constitution didn't lay out the number of justices that they would have.
So people that decry and complain about an activist Supreme Court, they could fix it.
Yeah.
By expanding the number of justices,
Yeah, it's so
and their
simple.
favorite president of their choice
Yeah,
could
exactly.
make the nominations.
Yeah.
Okay. An interesting sort of safety valve, but it's kind of rusty and stuck. I mean, it's not an easy one.
No, it is not an easy one, and, by design of the framers.
Yeah.
So.
You know what strikes me about everything we've talked about so far is there's no easy way to get around things. There are ways around, but they're not easy. These are not shortcuts. These are detours. These are detours over hill and dale and rock and vale.
Right. The framers, was it because of a certain arrogance, a certain ego, a certain righteousness in their cause?
A certain distrust of government.
Maybe.
And the mob.
Maybe. They set up a system that's hard to change.
Yeah. It is. You can change it.
You can change it, but it's going to take tremendous political resources.
And
you can't sit there and complain it's hard. Yeah, it's hard. So what?
Yeah,
it's the system.
You need to have an argument that resonates and is valid with enough supporters that you can get it made.
Exactly.
You can't do it for frivolous reasons. Just because you don't like something today. I mean, these have long-term implications.
Yes, they do. Now, you notice that this establishing the Supreme Court and the inferior courts didn't list qualifications for justices.
Just says there are one.
Yeah. And it didn't give terms.
So we're going to establish this court, and then we're going to worry about that stuff later?
I think more correctly, they've assumed that George Washington would work to figure things out later.
Well, okay.
Okay.
Somebody other than...
Yeah. So, in other words, they really didn't have a good idea of what the Supreme Court should do.
Yeah.
Or how many people should be on it. Or what the qualifications for justice
Well, and it's morphed over time, too. I mean, the reason they didn't have an idea for what the Supreme Court should do because we hadn't established judicial review in the Constitution.
Right, and we'll get to that.
Yeah.
I want to get to that because that's an important part of this thing.
Yeah.
But before that, they didn't even establish the qualifications for justices. You
Yeah.
notice they did for Congress,
Yeah.
both houses, the president, but not the Supreme Court.
So you could appoint an 8-year-old.
You could appoint an 8-year-old if you
You
want
could
to.
appoint a natural-born citizen of Cuba.
Yeah. And no term limits.
This is really open-ended.
It certainly is. And so what this has led to, and we need to deal with it, are the appointment of people who served on the court and were on so long that their mental faculties were greatly diminished. And maybe we're not in the right frame of mind to be serving on the Supreme Court.
That's why you have impeachment.
No.
No?
Impeachment is for
High crimes and
Yeah.
bribery and
Treason.
okay, you're right. Not incompetence.
not incompetence, not
Or incontinence.
exactly. So there's actually this problem, and there's been workarounds by the justices themselves when they realize one of their colleagues can't do the job.
Keeps falling asleep at meetings.
Well, not
things
just,
like that.
Not just falling asleep, but writing opinions that never get published that quote birds and trees that the justice talked to.
This has happened.
This has happened. So we and what can you do about that? Can the justice go to a colleague and say it's time to go?
Well,
that would be in violation of the Constitution.
Really?
The Constitution says you're appointed for life on good behavior.
But I couldn't, as a friend, come over to you at a cocktail party as you're busy guzzling Geritol and say, Paul,
It's time to
I
go.
hate to break this to you, but you're kind of done here.
And you say, more Geritol.
Yeah, more Geritol, and this time with more vodka. Interesting.
You're appointed by the president, confirmed by the Senate. Does anybody else have the right to tell you it's time to go?
Well, not the right, but can you do it as a friend?
Can you do it as a friend? Yeah. Well, when it's happened once with Justice William O. Douglas, who was appointed by Franklin D. Roosevelt,
Yeah.
when it came near the end of his time, justices were concerned about his mental and physical health. And they went to him, and they felt really uncomfortable. They felt that they were doing something unconstitutional in approaching him.
Wow.
Simply because of the way
The document's written.
the
Okay.
Constitution's written. It puts a burden on the justices who are there to interpret it, and you can't then do an end around just because one of your colleagues is not doing well. So, one of the disadvantages of being able to sit there. Now, I have to tell you, Congress is very aware of this, and Congress has said we need to fix this issue. How do you get a justice or a judge off a court? You set up a pension plan for them. And so the first pensions were provided as a mechanism to get justices and judges to retire.
Huh.
Okay?
Still get paid without having to do all the hassle.
Yeah,
You don't have to
exactly.
wear that black dress every day.
Yeah, so when they set up the pensions for these people, they expected some of the justices to step down. And they quickly found out that the justices and the judges weren't stepping down. And they go, why aren't you quitting? You get the same salary when you leave. And the word came back, well, you're not taking care of my spouse. I die, my spouse is going to be penniless. And so then they extended the pensions to the spouses too, as a way to encourage people to get off the bench.
Now, is this pension system the same for other government officials?
It was started for the justices and the judges.
Yes.
And then over time it's expanded to others. And to be honest, I don't know all the particulars for anybody else.
Yeah. Interesting.
Yeah. So, I mean, that's when you're stuck with the words of the Constitution, then you have to apply them. And it's like, well, we got these incompetent people. What do we do about it?
Yeah. And they're not incompetent because, they're bad guys. They're just, they've gotten to the point.
Yeah.
Okay.
It's time to go. Now, judicial review. You notice
Are we going to talk about that future?
we should talk about it right now because I hate to say it, this is where it comes up.
Really? In this first statement?
In the first statement. And here we have, what is the job of the Supreme Court? It says the judicial power of the United States shall be vested in one Supreme Court and in inferior courts. And that's it. It doesn't say what the job of the courts is, other than it's a judicial power.
So they're an organization in search of a mission.
You got it. And George Washington appointed 6 justices to the Supreme Court. They got up there and they're serving, and they realized what a boring job we have.
Yeah.
Because what kind of cases came up at the beginning? Admiralty cases.
Yeah, cases, disputes between states. No, the boat was in North Carolina. No, the boat was in South Carolina.
Or not even the boat, the cargo that washed offshore.
Yeah.
So, or off the boat and came onto our beach. Who owns it? That kind of stuff. And John Jay, for example, on the original Supreme Court, was so bored he quit to join the Supreme Court of New York. Okay? That's how meaningless the job of the Supreme Court was when it was first established. The first 10 years, nobody wanted to serve because nobody wanted to take these really boring cases.
Yeah.
And so it was John Marshall, the first great Chief Justice of the Supreme Court, who really set out to try to fix that.
Yeah.
And he said, really, what is the job of the Supreme Court? And through a case called Marbury versus Madison.
Yeah, Marbury v. Madison, absolutely.
1803, he and the other justices really created the concept of judicial review, where the Supreme Court has taken upon itself. It's not given into it in the Constitution.
Correct.
It took it upon itself. It's a power grab. The right to look and determine if a law passed by Congress is constitutional or not.
And didn't it have to do with midnight appointments and things like that?
Sure did, yeah. Madison, of course, in the case was James Madison. At the time, I believe, Secretary of State. And Marbury wanted a job.
Yeah.
So you mess with people's livelihood, and the Constitution is changed forever. Or the interpretation and all that.
Interesting.
Yeah. So that's where the power came for the Supreme Court.
Because it was written as very open-ended.
Yeah.
And they were able to do a power grab without being restricted from doing a power grab.
And, of course, they got criticized for doing that power grab.
Yeah.
Yeah.
But
who gave you the right to sit there and say Congress is acting unconstitutionally?
Show me where it doesn't.
Yeah, is exactly the response. So, and I think this is an important lesson that we've hinted on before. So much of the power that institutions have is because the individuals in those institutions have seized on opportunities to grab the power.
Yeah.
And say, it's mine. It's mine.
Doesn't say I can't, so I have.
So I have. And what are you going to do about it?
Yeah.
And you can't take away their pay.
That's right. You can't diminish their pay because that is in there. Fascinating.
I have a story about the pay, too.
Is that for this episode or a
It is
future
in
one?
this episode.
Okay, then let's have it.
Okay, we're going a little long here, but I just got to bring this up. So, under the words that we just read,
Yes.
a compensation which shall not be diminished during their continuance in office. So, when Bill Clinton was president, there was a tax increase that was passed.
Mm-hmm.
One federal judge said, my pay can't be diminished.
And you're diminishing it because you are starting to cut more into my pay with this tax. Got it.
So he filed a lawsuit, federal lawsuit. The problem is every single judge has a conflict of interest.
Oh, yeah. How do you solve that?
Well, it makes its way up to the Supreme Court, who are not as governed by conflict of interest rules.
Sure.
So they can, and this is actually smart, they can make decisions that can affect them. They were stuck in this situation. Oh, my God, what do we do here?
Yeah.
And they ruled against the federal judge.
So quit your whining, suck it up. We're all getting stung here, and that's just the way it goes. But otherwise, we set dangerous precedent.
Yeah, exactly. Exactly. So
where was the originator of this case from?
I don't know.
Yeah,
I don't
know. But it's California. I'm just saying. Sounds
He's
like a
just
California
saying,
thing.
I don't know. I for some reason I have in my mind North Carolina, but
oh, right. Well, that makes sense.
See, I have no idea.
Fascinating.
But it just, you can imagine a judge just angry at this tax increase, saying, "You can't cut my pay."
That's an interesting read and a good
Yeah.
a good tactic.
Yeah. Didn't work.
Didn't
Thank
work.
God.
But the Supreme Court was going,
Yeah.
we'd better think about this long and hard.
Yeah. And that no cut in compensation, of course, is important because the last thing you want is a court that's susceptible to Congress, which controls the purse strings.
Yeah, it makes perfect sense why you don't want to cut it.
Yeah. But tax cuts, the tax increases are okay.
I think it would be different if they passed a tax just on judges.
Yeah. That would be a whole nother
That
story.
would be a whole nother story. Okay, so
I think we covered it.
that's our line.
Yes.
And so we'll pick up. Now, this is Article 3. This was Section 1, and Section 1 is Section 1.
It's
There's
Section
no
1.
clauses or anything else. It's just that statement.
It's just a dump. Here's all these rules and stuff.
All right, and so, or here's a lot of stuff without rules, and
Yeah,
then y'all
exactly.
make it up.
Yeah.
And so now
But don't cut our pay.
But don't cut our pay. So we're going into Section 2 next time, and it's a little more
Yes.
nuanced.
Yes.
Okay, so that's our line. We'll come up with the next line next time. Thanks.